Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. The usual disclaimers about no attorney-client relationship apply, as you would have heard when you logged into the call. I did not get a chance to read the questions today. I was very busy. But we'll just go over the questions. I don't have time for new questions today, so we'll just do the questions. I started reading them about a couple of minutes ago, so I went through them really quickly. I hope you're on the phone. If I missed something, just remind me. Okay, so the first question from Karthik is, I received an audit on PERM. I'm working remotely. See, Karthik, working remotely is by itself not an issue. The only issue I have seen come up, well, one of the only issues, I would say 2 or 3 main issues come up. It's important to understand where the job is located. So if the job is located in the corporate headquarters but allows you to work remotely, the fact that the job allows you to work remotely should be expressly stated in the ads, because Department of Labor thinks of it as a perk, as a benefit of an employment where you are allowed to work from home or remotely. So as long as the job is identified as being located somewhere such as corporate headquarters, and as long as the fact that the job allows you to work remotely is mentioned in the ads, etc., and the ETA 9089, you should be okay. I don't necessarily see any problem with this. And for the H-1B extension, you don't need to worry, because even if you lose the PERM, so let's assume the worst. If you lose the PERM, you can just file an appeal, and once you get the extension, you can withdraw and refile another labor certification, another PERM application. Remember, appeal against a PERM denial currently stays pending for about 3 years, 3.5 years. While that appeal is pending, you can keep getting H-1B extensions. But the proper thing to do is to file the appeal, get your extension, and then withdraw the appeal and refile the case. Okay? *5 if you have a follow-up question. Press *5 on your phone. Press *5. Okay, so let's see, where is this caller from? We have one question. Why can't I see you? Okay, area code 225. Go ahead, please.
Yeah. My employer says that she did mention on the notification that the work remotely is there. So I was just trying to verify it with you to get your inputs on that.
Yeah,
what do you mention?
I actually looked into this issue just recently. We filed a case for somebody whose job is located in Virginia, but they are working out of California. And from the decisions and from the law on this issue, I concluded that as long as we make 2 things clear, where the job is located and that the job, no matter where it is located, allows you to work remotely from any location, you're fine.
Okay.
Okay?
All right. Thank you.
You're welcome. All right. This was Louisiana. Let's go on to the next question. Folks, as I mentioned earlier, I didn't have time to really review the questions today. I went through them like in just a 3-minute period. So if I missed something, feel free to just press *5 and remind me that I missed something. So we finished Karthik's question. Confused immigrant says, my original H-1 with employer A was approved in 2012. I worked with them till 2015. Green card was not filed. After that, I changed to H-4. Now remember, any time that you have spent on H-4 or L-2 type visas does not count towards your H-1 or L-1. So if you spend time on H-4, it does not count towards your H-1. Okay. So you asked me, these 10 months between Jan and November will be counted against 6 years of H1. or they can be recaptured. They can be recaptured. *5 if you have a follow-up question, *5. So yeah, H4 is not counted. This was a parting gift from Bill Yates in, if I remember correctly, I think it was back in 2010 or 5, something like that, long time ago. On December 31st, on the year Bill Yates was retiring, he was, I think he was the chief of operations, service center operations. He did what is called decoupling. Decoupling means, he said, H1 and H4 are separate things. The time you spend towards on H4 doesn't count towards your H1 6 years. Okay, no questions. We'll go on to the next question. Arjun D. He's on H1B, wife on H4, 6-month-old son, US citizen. Wife went to India, visa stamping. Parents' visitor visa, her parents' visitor visa has been rejected 3 times in the past. So the question is, can we take a family appointment? I'm not aware of this level of detail, Arjunji. I normally have one of our colleagues look into it and get back with me about this. If it is allowed, going together is okay. I'm not sure it will make much of a difference. It might. It all depends upon the consular officer who's interviewing. I'm not sure that going as a family has any particular advantage, but there's no harm. You've tried it the other way. So if the law allows, it's not the law, it's the local policies and procedures. If they allow you all to go together, sure, go ahead. I don't have any definitive opinions one way or another on this. Somebody from area code 469 just raised their hand. I'm not sure what this is about. Let's try it. Area code 469, go ahead, please.
Yeah, I posted this question actually. So my concern was, will it have an impact on her visa getting sent? I mean,
no, I don't think so, sir. I don't think so, Arjun.
Okay.
Yeah, I don't see any problem with that.
And their visa actually got rejected in June. So
yeah,
is it
I saw
like
that. See, I don't know.
Go now?
I don't know what the local rules allow. There used to be one-time local rules were that you couldn't, if you've been rejected twice, you couldn't apply like within 6 months or something like that. You have to check what the local rules are. These are not standard national policies. Okay.
So I have to check in on India website for US Embassy?
Right. The rules or the policies within India would be the same. So any consulate will give you the same rules. Okay.
Okay.
Good luck.
All right, thank you.
Okay, let's go on to the next question. Folks who are just joining us now, I will not have time for new questions. I don't think so. So we'll just do the questions that have been posted and follow-ups on that. Next question is from... Oh, you also, Arjun, I meant to also answer this. I'm not sure why the visa is getting rejected. They have their own business in India. Tourist visas can be, or business visas can be rejected for many reasons, not the least of which is, oh, we don't believe you, we don't think you're going to come back. So really, it's more of an excuse for them not to give a visa to anybody they don't want to. Why they don't want to, it's a judgment call. I can't really tell you that there is any rhyme or reason in it. Some categories of people I can understand. If you are young and single, in between jobs, okay, well, maybe you won't get a visa. That makes sense. But for established people who have their lives set up in India, I don't see why they should be denied, but they are denied nonetheless. Arvind says, I got employment-based EB2 green card through consular. Wife is derivative on EB2. She's planning to apply for citizenship. After she's approved, then I'll apply for citizenship. That's what I normally recommend to people anyway. Biometrics. What type of biometrics? Just the normal biometrics, your fingerprints, etc. They do FBI check. Having minor traffic citations is not an issue at all. The only time I have seen traffic violations become a problem is if you have too many of them, and usually moving violations. If these are violations like you parked somewhere illegally, that's not really an issue at all. But if you, let's say you get 100 traffic tickets in 2 years, I think you have a problem. That goes to good moral character. If you keep getting tickets for speeding, When I went for my naturalization, I had a few speeding tickets. I think I had like 12 or 13 speeding tickets in 2 years, and a part of it was that we were doing a lot of trials, and I was always running from one court to another. So, and they did ask me that and said, "What's going on, counsel?" And I explained that that's the nature of our job, and sometimes we don't have a choice. So I personally don't think that having traffic violations, unless they are moving violations and too many, how much is too much, I do not know the answer to that question. But I would say anywhere more than 4 or 5 moving violations in a year could be questionable. 1 year out of last 8, she didn't file taxes because she was not making enough money and you're filing separately. I don't see any problem with that. That should be fine. See, you don't need to bring an affidavit with you because they put you under oath. So when you go for your 485 interview, they put you under oath. She can bring a statement from the CPA saying that she doesn't need to file taxes. That's not a bad idea. Is there any problem in her applying for citizenship before you because she's a derivative? I don't see any problem with that. We do this all the time. Can the interviewing officer ask her about whether you stayed with your employer after coming to USA? And the answer is probably not. Probably not. But it is not forbidden. They can look into anything they want to, which they think is pertinent. And if you came and work here for 10 months after green card approval, I don't think it has a problem at all. Should she carry pay stubs? The way I look at it, Arvindji, carrying extra is not an issue. She should. Because if she doesn't have all the documents, it's not like they're going to deny the case. They'll issue a request for evidence that could delay the case a few weeks more. So if you have the information right there, you can give it to them right there. Is there a document list? Oh, I don't have a document list other than saying whatever you have, take it. Take a whole big file. *5 if you have a follow-up question on this, guys. *5. Press *5 on your phone. Okay. Let's go on to the next one. Prasad Gupta. H1B since 2004, waiting for green card via employment. He's been working for company A for last 12 years. Filed EB3 in 2009. Then did an upgrade to EB2 in 2016. I-140 is approved on both EB3 and EB2 and waiting to file I-485. Can I file 485 if EB3 dates become current? Oh, absolutely. Because you are entitled to your earliest priority date, no matter which category you file under. And if you have approvals under 2 categories, you can file under any category you choose as long as the job is available. I'm also asked this question, if I'm approved under EB2, can I file under EB3? And the answer is, I don't know. What do? We usually first get an EB2 approval, then using the same labor cert copy, file for an EB3 approval also. So I do need 2 I-140s in my opinion, one under EB3 and one under EB2. So even if Mr. Gupta has his green card approved under 2 categories, but even if you had only EB2, you could also get an EB3 approval with a different I-140 using a copy of the same labor certification. What if my company lays off before or after filing I-485? See, before filing I-485 is problematic because then you will not be able to file a 485. You'll have to start a green card through another employer, but you'll carry the same priority date. After I-485, things get a little easier. Why? Because once I-485 stays pending for 180 days, and if the employer doesn't take the efforts to try to inform the government or anything, you can take a same or similar job as long as you don't get an RFE within 180 days. If you don't get an RFE, then if you get an RFE after 180 days, for AC-21 portability to kick in, you do not have to be employed with the same employer for 180 days after filing 485. You just have to be employed with them when you filed 485, or you must have the job offer open when you filed 485. I hope that makes sense. Can I take EB3 role to avoid the layoff? Yes, you can. And you can file your 485, yes, under EB3 category, or if the EB2 job will be open in future. This gets a little complicated. You might want to talk with your lawyers or set up a consultation with us, because there are certain elements in it that you should explore with us one-on-one. What will be the process if I chose to leave the company and join a similar position? I don't see any problem with that, as long as 180 days are over, or at least you're not questioned before 180 days. *5 if you have a follow-up question on this. *5. Sometimes I go too fast, so if something is not clear, just press *5 and ask me to clarify. Please don't hesitate on that. Okay, then we get to B. Sundar. Scheduled wife's H4 visa interview sometimes in April. Decided to cancel because employer had filed for H1. We did cancel the appointment, but we did not cancel the DS-160. Mr. Sundar, I don't know to this detail what you're supposed to do, but if you read the frequently asked questions on the State Department website, they tell you exactly what you have to do to make corrections to your DS-160, or even to delete your 160 and refile it. I would look into the frequently asked questions of the State Department. I think they cover this issue. If they don't, get back onto this and maybe we can talk about it. Tell me what you found out from their frequently asked questions. *5 if you have a follow-up question. *5. Okay. Sen 1. Valid H1B until 2018 December, but applied for change of status to H4 and H4 EAD in July. Should I stop working once we receive the H4 receipt date? No. Once you get the H4 approval. Receipt doesn't mean anything. It's the approval that requires you to stop working on H1 and wait till the H4 EAD comes. *5 if you have a follow-up question on this. *5. Okay. So this is Ms. Sen, I guess. Ms. Sen, go ahead.
Hello?
Oh, Mr. Sen.
Yeah. See, will there be problem, in the 485?
No, not at all. Not at all.
Good.
Okay.
But I can work till the H1 approval is come to my end, correct?
Till the H4 approval comes in your hands, yes.
Okay, fine. So I will not have any problem with 485, any of this.
No.
But I can't recapture the period, correct?
Can you recapture the period that you were on H4 EAD? Absolutely. Yes, you can. So if you had, let's say you've done 5 years of H1, then for 2 years you were on H4, you still have 1 year of H1 left.
Okay. So in my case, I have only 6 months of H1 left. So that's the reason, I'm applying for change of status.
Right.
So probably once H4 EAD, H4 change of status comes, I need to stop working,
Right.
and I can use the remaining 6 months, later, for the recap, correct?
That is correct. Yes, sir. Okay.
Okay. Thank you, sir.
You're welcome. Okay. Next question is from Vishal Goyal. Priority date is March 2010. Working on EAD since 2012. PERM was filed under Director of Quality Assurance. Recently received an EVL RFE. I have 3 options to provide an EVL. I don't know what EVL means. I keep forgetting this. Is this end client, vendor, something like that? Is that what you guys use? Because that's the language that I always have trouble with. I just saw that there was a hand up from area code 201. Area code 201, go ahead, please.
This is Vishal, Rajiv. Thank you for the question. Taking the question.
Vishal, EVL is what? End client, vendor, something like that?
Employment verification letter, primarily.
I always have a problem with that. I can never keep this straight. Okay. Employer verification letter, of course. Employer verification letter. Now, you see, you have given us 3 scenarios, right? Current employer, product-based startup, small IT. None of them is perfect. Okay? None of them is perfect. But I like the if you are doing 485 portability, I like the product-based company because, but you said they have only 500 or 500,000 in revenue.
500,000, sorry.
Okay.
Yep.
Okay. They have no full-time employees. That I don't like. IT consulting company, they create problems. They can create problems saying, well, your jobs are not really permanent, and employer-employee relationship. But if you are director of quality assurance, one second, for a future employment on the same role, but how would you be a director of QA if they are a consulting company with no in-house development, right?
Some in-house development. They have a product and they also do consulting.
Is it a mature product? Is it being used?
I think they have a couple of clients, insurance clients on that product.
Well, a couple of clients on a QRAM and couple of clients in Microsoft Access are two different things. So are these huge licensing fees, $1 million plus or something like that?
I doubt it. I think it'll be like 400, 500K subscription.
Well, that's not bad. That's not bad.
Yeah.
I think a small IT consulting company sounds okay.
You think my current employer, because they are a pretty big firm, they're about $1 billion in revenue, and I'm working for them as director of business development, and I have a lot of 50% or so responsibilities.
Well, you see, that is so
in line with what
that is so difficult to predict. But here is the good news. The good news is that under the current rules, you can file a supplement J and wait for it to be adjudicated. And if it gets adjudicated against you, you can just give another supplement J for another company.
Got it. Got it.
It didn't used to be available to us earlier. It didn't used to be available earlier, but now it is available.
Okay. Got it. Got it.
Okay.
So that's very interesting, actually.
Yeah.
Thanks for that info. Yep.
Yeah. All right.
And can I ask you with this one follow-up question there, Rajiv, without monopolizing your time? Can my current employer file, while my other application is still in process as in more so tech role, can my current employer also file another application
for green card?
in parallel, and then ultimately
for green card? Absolutely. That's what I always do. If I have my doubts, this happens all the time. So let's say we started working with a company, there were only 20 employees. Green card keeps going 7-8 years, they've become 200 employees. The guy who was supposed to be team leader is now director product delivery. Okay. So when I look at that situation, I always tell them, guys, I'm going to start a second green card.
Yeah.
Okay. That way I have
it won't hamper process one, right?
I have a fallback position. Absolutely. Go for it.
Yeah, and then I can port the priority date in case this gets denied for some reason, right?
You got that right. Absolutely.
Yep. And my wife cannot port the green card date, right? For the priority date?
Nope.
Yeah, it's only me.
Nope.
Okay. Got it.
Okay.
It's extremely helpful, Rajiv. Thank you so much for taking the question.
Good luck, Mr. Goel. Bye-bye.
Thank you.
Okay, let's go on to the next one, guys. That's Madhusudanan. Madhusudanan says, I heard there's a proposal to deny immigrant green card if petitioner used Obamacare. Well, guys, the Obamacare issue, I haven't looked into it in detail. I did speak about it on one of the NPR radio affiliates. I think it was a couple of months ago when the government first started floating this issue around. I had reviewed the issues. Obamacare was not an issue at this time. I'll give you a quick rundown. I don't think they can go back and change the law. I don't see how they can do that. However, the current law is you can use public benefits as long as they are not being used to supplement your income and they are not being used for long-term medical care. Okay, so if you're like an assisted living home facility, that could be a ground for deportation. Or if you are taking money from the government, other benefits, they have been letting them slide. But what Trump wants to do is he wants to come and smack on all these tertiary provisions onto the laws, but they'll have to give us enough notice. It's not going to happen overnight, and they can't make it retroactive. Okay, so think about it, how unfair it would be if all of a sudden the state of Maryland said, okay, our speeding laws now say that a speed limit is going to be 35 miles an hour instead of 55, going back to January 1st of this year. So everybody who was driving more than 35 miles an hour now gets a ticket. Well, that's nonsense. You can't go back and change the laws and change rules for the conduct that has already occurred. You have to give me some warning on that. So I think that's very unlikely to be an issue for people who have already undergone or done the conduct. Okay, so I wouldn't worry about it, not at this time. But we'll keep an eye on it, and I always update people on social media, our website, on my Twitter, my Google Plus, and my Facebook pages. Do I have anything else? Yeah, I think those three are very. I'm most active on Twitter, actually, also LinkedIn. So just go ahead and follow me there. We keep people updated, and I'm sure these days there's so much information on the internet also. *5 if you have a follow-up question about the Obamacare issue, *5. Okay, so let's go on to the next one. This one is HAB 485 adjustment EB to India pending since 2012, working on EAD. Priority date is June 2009. It may become current soon. Will I have to appear for an interview? Maybe, maybe not, because there was a date, I think the cutoff date was March 2017 or something like that, or May 2017. Cases filed before then were being interviewed at random. Not everybody was being interviewed. But since that date, whatever that cutoff date is, everybody will be interviewed. General thoughts, recommendations for the interview for adjustment of status. Oh, that's a complete topic by itself. I would say normally these tend to be fairly easygoing interviews. That's not the end of the world. Maybe I'll mark it as a frequently asked question and spend some time on this. So the way this works is, when you go in for the 485 adjustment of status interview on employment-based cases, the officer will come and get you from the waiting room. You'll go in with them. They'll say, raise your right hand. State whatever you're about to state is the truth and nothing but the truth. You say, I do. And you sit down. This will be, you're now under oath. Whatever you say carries a penalty of perjury. So typically the officer will first go over the I-485 form. Is this where you live? Is this your date of birth? Etc. etc. Then they'll ask you questions about, about your current employment, your offered job, what do you do now? Do you have your couple of pay stubs, last 3 pay stubs, something like that. That's after this comes the next part, which is what was your background. So I had a case recently in which government denied naturalization based upon some event that occurred 10 years ago, where they said, well, we shouldn't have approved your green card because the company that you were working for was hauled up for fraud. The individual was not involved with it. So they contacted our office. They asked me to go with them for appeal, a citizenship appeal. And normally last 30 years, I've never gone for any interviews. But in the last 1 year, I have gone for so many interviews because things have become more complicated. So I went in, I explained to the officer, the hearing officer, that look, there is it so happened that that company which was hauled up for fraud, I had represented that company. The employer was a very nice guy. First thing he told me was, no matter what happens, make sure that the employees of the company are protected and they are taken care of. So I tried to negotiate. He was being represented for criminal defense by somebody else, of course. We worked with the Criminal Defense Council, and I discussed it with the prosecuting lawyers, the government lawyers, how we can protect the employees, and there were some email exchanges. So I actually took in those email exchanges because the company is no longer in existence, and the emails didn't contain any confidential information per se. we were able to demonstrate that none of the employees were involved in the fraud. So they could go back 10, 15 years and start looking at those things. Sometimes you go for naturalization and you could get your green card into trouble. Okay, but if you have a clean history, you wouldn't have to worry about it. They look at the history, then they look at whether or not you have any unauthorized employment, or you were working on an H-1B at a location where you were not authorized to work. These are some of the things they look at typically. Okay, star 5 if you have a follow-up question. Star 5. Okay, I forgot to answer one more question you have. Any particular recommendations, adjustment of status versus consular? Almost always adjustment of status, unless you are statutorily barred from adjustment of status for some reason. I prefer that you go through it here than going through it in your home country. Okay. Next question is Mage. Previously on OPT, expired in March 2018, filed for L2 change of status and EAD. What is the expected time frame? I have no idea what the time frame is. Whatever the time frame Vermont Service Center gives, in your case, that is probably it. Once I exceed the 60-day grace period after expiration of my OPT, am I accruing unlawful presence? No, you're not. Because if you filed your L2 change of status within your OPT or the 60-day grace period following the OPT, and the application was received by the USCIS, you are in authorized period of stay. You are not unlawfully present. Now, under the NTA policy, which has been since then called off, there is no NTA policy right now. Things might have been different once the grace period is over. If the L2 gets denied, you could have an issue. But that policy was called off for now at least, so we don't need to worry about it. There is no NTA policy right now. Star 5 if you have a follow-up question, folks. Star 5. Okay. This one is area code 646. 646, go ahead, please.
Hi, I had a follow-up question.
Ma'am, you're actually breaking up quite a bit. I cannot hear you very well.
Can you hear me now?
A little better. Go ahead.
So is the timeline for I-539, I-76 files concurrently the same as if an I-539 was filed on its own?
I believe so. Yes, ma'am. But remember, there's no guarantee that they will adjudicate the employment authorization in the same period as they do your I-539. They often do, but it's not guaranteed, nor is it required by law.
Okay, I understand.
All right.
Thank you.
Good luck. Okay. Let's go to the next question from Suresh Ranga, who has filed for adjustment of status 485, provided affidavits from mom and dad before. Okay, these are affidavits. I was born during 1968 when reporting births was voluntary based on Indian Births and Deaths Act of 1969. I do have secondary evidences. You should get a non-availability certificate. Okay, you should, because we've been giving them uniformly. They've been asking for them uniformly as well. Getting anything from the Indian embassy is not going to help. What you can do is hire somebody. You can contact a local lawyer in India, have them go to the local authorities. I don't know where you were born. If you were born in the South, get yourself a lawyer in the South. We have a lawyer in New Delhi that we have used from time to time to get documents from India. Whatever they charge, you can contact them. You can send me an email to help@immigration.com if you don't have lawyers. We can put you in touch with Manoj. Maybe they can help. You can check with them. But somebody should go and get your non-availability certificate. And it shouldn't be that complicated. I mean, anybody from your family can do it. You shouldn't have to hire a lawyer for something simple like that. Affidavits from parents are enough if they are accompanied by non-availability. Okay. *5 if you have a follow-up question. *5. Okay. This one is from California. California, go ahead, please.
Thank you, Rajiv. I mean, the person you said will be able to help even if the non-availability certificate is needed from South?
I can ask them. There's no harm in asking. Send me an email to help@immigration.com. Okay.
Sure, I will do that. Thank you,
Yeah,
Rajiv.
I'll ask Manoj if they can. I mean, these guys are very honest. Whatever they can do, they'll let you know. Okay.
Thank you so much.
Take care. Bye-bye. Okay. Then the next question is SAF 777. Currently on H1B, working full-time with the same employer last 4 years. Good till 2021. Green card under EB2. I-140 approved. Congratulations. Wife is on H4 visa, looking to apply for EAD. If I change employers now, will my date remain the current? And the answer is yes. Should I wait for 180 days? Look, your priority date is yours to keep the moment the I-140 is approved. The only time you lose it is if your I-140 was approved in error or there was fraud. As long as it is not either one of those cases, the moment the I-140 is approved, the priority date becomes your property. However, after 180 days of it staying approved, you don't have to be employed with the employer. As long as the I-140 is not revoked, you have an additional benefit that you can use that I-140, even if it is revoked later on, to extend your H1 with any employer past 6 years. I hope that is clear. *5 if you have any question about this. Okay, so if you oh, you're here, good. Okay, I'm just going to answer the rest of your questions. This is SAF 777, right? That's you?
Yes.
Okay, good. So your second question is, how long is the wait time for me to get green card process started? There's no wait time. You can start same time as H1, even before the H1. That's not a problem. Okay. Then since the new employer will have at least 6 months of probation time. Now that must be their local rule. Otherwise, there's no immigration law. If the priority date becomes current in the next year or two, what are my options? See, remember, if the priority date becomes current, you have the option but not the obligation to file your 485 right away. So while your second green card is going on, you can file 485 a year later if the dates are still current or they have been current or they have gone past current for you. So it's not like your date will get stale. Let's say my priority date became current this year and then I file a 485 2 years later. That's perfectly fine as long as on the date I filed the 485, the dates are current or they are past the current date. So if in, let's say this year it's 2002, dates became current, and then 2 years later the dates are at 2003, I can still file my 485 because my dates are current. They are prior to 2003. I hope that makes sense. Does that make sense? You understand?
Yes.
Okay.
The only thing here is that if with the new employer, they're still like in the process of filing the green card, for example, and the date becomes current.
You can't file 485. You can't file 485 unless you are willing to go back with the old employer and the old employer is willing to take you back.
If in case the old employer does not have that position open for me anymore, then will it be possible to switch over to this new employer under AC21?
No, AC21 only kicks in if the 485 is validly filed and stays pending for 180 days. AC21 does not even begin until 485 is filed.
Okay, so then there is always a risk that with the new employer, if the date becomes current, then there might be a chance of, losing the, if the date becomes current for 6 months and then there's retrogression, then there is a chance that
you have to wait. You have to wait till the dates become current again. But I mean, I personally think it's a relatively minor risk. If you have a good job offer, you should consider it.
Okay. All right.
Okay.
Thank you very much.
Good luck. Okay, next question is NABZZ. I'm currently on H1B, got an audit in PERM. The lawyer has submitted a response to the audit. How much time the Department of Labor takes? I don't know these times, guys. Our team takes care of this, but I know that they are not very long. Audit response times used to be months and months and months. I would be surprised if it's more than a few weeks. Can I switch to a different employer? You can switch with any employer at any time you like. Until I-140 is approved, you don't get anything out of the process. Your priority date is not yours. Only if the I-140 is approved, the priority date becomes your property. Getting married in November, congratulations. Planning to get my wife on H4 visa. Any issue if I change my employer 2 months before my marriage? No issue at all. I don't see any problem with that. Star 5, okay, this is from area code 408. Okay, area code 408, California. Go ahead, please.
Hi, Rajiv. Thanks for taking my question. So my follow-up question was, so if I change my employer, I would have to get my visa stamped again if I go to India. So getting my H1 and my wife H4 at the same time, would it be an issue or would be a normal thing?
No issue at all. It's done all the time.
Okay. Yeah.
Okay.
That's all.
Good luck.
Thank you.
All right. Bye-bye. Oh, I just remembered something. I think I forgot to answer one question. Oh no, I covered it. Okay. Now comes Raghu. I have the following questions regarding traffic violations for naturalization. Involved in an accident, no traffic ticket, not a problem. Involved in an accident, do I need to mention? Look, I always err on the side of caution. Whenever you have an issue like this, just put a little addendum saying that just exactly what you said here. Number 1, number 2, number 3, this happened. Just disclose it. I don't think it's a problem of any kind. I don't see any issue arising out of these things. So just attach an addendum saying these things happened. They probably don't need that, but no harm in being over careful. Star 5, if there's a follow-up question, star 5. Okay, there it is. It's from New Jersey. New Jersey, go ahead, please.
Hello, Rajiv. This is Raghu.
Yes, sir.
Thanks for the answer.
Of course.
This is not exactly the same question. Like I want to ask based on the previous question, somebody's like regarding the 480, like applying for citizenship. My wife got a green card as a dependent, and when she started working, she worked for a company for 2 years. Then she changed the employer. Like later on, the first employer seems to be a fraud company. Now recently it has been listed as a fraud company. If she applies for the citizenship, so her first employment will be like when we give the date. So is there any problem like in case we find out as a W2?
Here is the thing. She was not the employment-based applicant. You were, right?
Yes.
Okay. So if her employer is involved in shady practices, unless she has been charged with those practices, I don't think she should have a problem. Now they might question her, it might come up, but it does not appear to me to be a serious issue. Okay.
Okay. Thank you very much.
Good luck. Okay, area code 501. Go ahead, area code 501. Go ahead.
Hi, Raju. This is regarding the traffic ticket, the current question you answered.
Right.
What about the parking tickets, Raju? Do we need to mention?
Parking tickets though don't even matter. No. There's no need to mention that. Okay.
Thank you, Raju.
You're welcome. Okay. So, that's NABZ again. I'm filing for an H1B transfer to another employer. Okay, let me see what your original question was. Oh, the audit. Okay. So, I'm filing for an H-1B transfer to another employer on the condition that I will leave my current employer only if my H-1B transfer is approved. If the H-1B transfer is denied, can I continue working with? Yeah, of course. So if you are working with employer X on H-1B, you apply for another H-1B transfer to employer B, and the B gets denied, can you continue working on A? Yes. Not only that, let's say you filed for employer B and you started working with employer B, then employer B's got denied. You can go right back and start working with employer A again. Of course, if you never changed over to B, you can definitely continue working with employer A even if the B's H-1B is denied. No problem. *5 if you have a follow-up question. *5. Okay. And next question is from Samir K. Changed my employer based upon a receipt for H-1B transfer normal processing. This year it got denied based on specialty occupation. Employer refiled after changing the job code and it got approved. Yeah, there is no I-94, so you have been accruing unlawful presence from the date of the H-1B transfer denial. Well, I don't see why you cannot use the old employer's visa. I think you can, because that visa is still valid. So I believe you could go outside USA, go to Mexico or Canada and come back showing the old employer's visa and the new employer's approval. Just make sure they don't give you an I-94 valid till only 2019. Sometimes they do that. Tell them that I'm entitled to my I-94 all the way to 2020. Okay. I don't see any problem with that, frankly. *5 if you have a follow-up question. *5. Okay, guys. Oh, there is a follow-up question. Area code 352. 352 is Florida. Florida, go ahead, please.
Hi, Rajiv. So I'm in a similar situation. My I-797 is approved, but my extension of stay is denied. So can I just go out of country and come back and ask for a new I-94 and at the port of entry and continue working for new employers?
Only if you have a visa already. Okay.
Yes, yeah, I have a visa from my previous employer, a valid visa.
I don't see any reason why you can't do that. I personally don't see any reason.
Okay.
I think you can. Okay.
Okay.
All right. Good luck to you.
Okay. Thank you.
You're welcome. Okay, guys. I've got actually 13 minutes. That's pretty good. We did very well today. Anybody has any question? Go ahead. Well, there's another question from area code 312, which is Illinois. Okay. 312. Go ahead, please. Okay. Maybe not. I'll put your hand down. Now, there's another question from area code 701, North Dakota. And, yeah, let's try this. Area code 701, go ahead, please. Yeah?
Hi, Rajiv. I had a quick question. So, I am from ROW, and I had my interview last month, my 45 interview. I have not got approval for my case yet, and I think the ROW EB3 retrograded starting September 2017, but this month is August, right? Mm-hmm. So would that retrogradation still apply?
Your I-45 is already pending, right?
Yep.
For the rest of the world, from what I remember of the remarks of the government, they were saying that everything will probably be restored back beginning October 1st. It's a temporary situation.
Yeah, but my question is, I went to InfoPass this morning and they told me that I must be receiving a letter or something within this week or something.
Oh, so, okay. Let me explain to you the way this process works, okay? So, once you go for your interview, 485 interview, after the case is decided, whether it is the same day or a month later, the USCIS officer who decides your case sends for a request for a visa number. That request is sent via email or via fax to the State Department. If they get your visa number before retrogression, you will get your approval even if the dates retrogress.
Okay.
Okay.
So I might be receiving my visa then.
You might be getting your
based on
approval.
what they said.
You might be getting your approval because it looks like chances are they already got your visa number.
Okay. Got it. Thanks a lot,
Oh,
Rajiv.
you're welcome. Good luck.
Bye.
Let's go to California. Is it California or am I on area code 312? Okay.
Hi, Rajiv.
Yeah, hi.
So my current H1B is valid till September 2019,
Okay.
and I'm changing my employer this month. So I'm doing H1B transfer, and I'm visiting India next month. So do I have to get the visa done again, H1B visa, or that visa will be valid till October?
Okay. Now you said you have a visa stamping with the current employer till October, right?
Yes.
Okay. If you, first of all, don't leave without filing the H1B transfer. And if you file the H1B transfer and leave, you can return on the same old visa. Okay.
Okay. And but in case I wanted to file H4 visa for my wife, so what will happen in that case?
You can try. I think it will get a little bit more complicated because your visa will not be for a very long duration. But I don't know what the consulate does in these cases. I would send them an email and find out what they want me to do. So let's ask them what they want you to do.
Okay, but I can do this thing, right? I can again get a visa interview for my new employer and then file for my H1.
You can always do that. That's definitely open to you. If you want to get the transfer approval and then go back to the consulate for your H1 and your spouse's H4, that's perfectly fine.
Okay, yeah, thank you.
You're welcome. Good luck. Okay. Now, this one I think is area code 312. 312?
Yes, hi. Just had a follow-up question on this filing the H4 EAD.
Yes, sir.
Can we file it ourselves even with the new form?
Yeah, of course.
There was a new I-76.
See, in the beginning,
Do I need a lawyer?
In the beginning, when the H4 EAD program came out, we had to charge a lot of money because we didn't know what we were supposed to be doing. We were getting ready for responding to all sorts of questions on the H1 process itself because it wasn't beyond imagination that government could start saying, okay, prove that the H1 is maintaining status. Where is he working? But as it went along, we realized that this is basically just a set of forms we have to file. So personally, I don't see, as long as you tell the truth, file all the right forms, I don't see the need for a lawyer.
Okay. Thank you.
You're welcome. Okay, let's go to area code 518. 518. That's New York.
Hi, Rajiv.
Hello.
Hi. My question is with regard to K1 visa. My nephew was here on K1 visa, fiance visa,
Ji.
and for some reason it didn't work out for him.
Okay.
So, what is the legal way for him to be able to stay here?
Ma'am, I don't know of any way. If a K1 guy doesn't get married within 90 days, they have to leave USA as far as I know.
Okay, he cannot get a F1 or something.
I don't believe so. I haven't looked at this particular area of the law for a long time, but from my last reading many years ago, what I remember is if it's K1, you have to be married or you have to leave USA. You can come back on an F1, but not in the same trip. Please double check this. I'm not sure about my answer.
So, when you mentioned come back, would there be an issue in applying for another visa, or they should not do anything if he left on time?
I think if he left on time, in a way, it shows that he has obeyed the laws and not tried to evade. But on the other hand, by applying for a K1, he's exhibited intent to stay in the USA. So that could become a negative factor for him. It is up to the consulate to assess whether they believe more in the negative factor or the positive factor.
Okay. All right. And one more question is about EAD. My EAD is pending on EB2. Business visa. My husband is on business visa. I am his dependent. So my EAD is in pending status. So can I still look for jobs, and should I be able to, tell them that it's in, process?
Well, you can't start working until your EAD is in hand, but there's no harm in looking for a job.
But would they be able to provide a job without, let's not start until
you cannot start working without the EAD.
Right. Okay. All right. Sounds good. Thank you so much.
You're very welcome. All right, guys, that was all the questions for the day. That's great. We did well today. Only about 4 minutes left in my time, which is pretty cool. Well, good luck to all of you, and I'll see you in 2 weeks. Always a pleasure talking with you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.